بسم الله الرحمن الرحيم الحمد لله رب العالمين وبه نستعين ونصلي ونسلم على خاتم النبيين نبينا محمد وعلى آله وصحبه أجمعين أما بعد رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. We begin in the name of Allah subhanahu wa ta'ala. We request praises and blessings upon Rasulullah sallallahu alayhi wa sallam. Allahumma alimna ma yanfa'una wa anfa'na bima 'allamtana wa zidna ilman wa 'amalan ya kareem. May Allah teach us that which benefits us and to bless us to benefit from that which He has taught us, and we ask Allah to increase us in knowledge and action. Ameen. Welcome everyone to part 3 of our morning series on the fiqh of Islamic transactions, and really an introduction to the fiqh of Islamic transactions. تقبل الله منا ومنكم صالح الأعمال. May Allah accept our deeds. Ameen. Today, no doubt, is the best day of the week, and we're grateful to Allah subhanahu wa ta'ala for what He has allowed us to achieve thus far on this day. Yesterday, we were discussing the types of transactions with regards to the time of exchange, the type of wealth that is exchanged, and so on and so forth. And we stopped at the point whereby we would now dive into the transaction. And continuing from where we left off, the fuqaha state that a transaction has arkan. Arkan meaning pillars. And there's a slight difference of opinion between the Hanafi madhab and the rest of the madhahib. But in essence, it's in the semantics of the discussion. But ultimately, all parties agree that a transaction would need a buyer, number one. Number two, a seller. Number three, the mediums of exchange, meaning the price and the product. And number four, the commission of contract. Commission of contract refers to al-ijab wal-qabul, meaning the offer and the acceptance. The offer and the acceptance. This is known as commission of contract. So, 4 pillars according to the majority of the scholars of Islam. Number one, the buyer. Number two, the seller. Number three, the mediums of exchange, meaning the price and product. Number four, commission of contract, meaning the offer and acceptance. That's what happens when we buy anything. If I come to you to purchase a vehicle, I'm the buyer, you the seller. The medium of exchange is the car versus the cash. If we're doing that sort of transaction, goods for money transaction. Or if it's a barter transaction, then the goods that you have versus the goods that I have. Yeah? And last but not least, the offer and the acceptance. The offer to buy the car for the amount, and the acceptance by the other party. Or vice versa. The seller offers to sell, and the buyer accepts to buy. Okay? So this is generally what is considered the pillars of a transaction. Now, from these pillars, the fuqaha have deduced conditions. Conditions that are connected to these pillars. And conditions are matters that have to be met for a transaction to be correct. Just like, for example, when we say wudu is a condition for salah. What does that mean? That means for your salah to be correct, you have to have wudu. On condition of you having wudu, your salah qualifies to be correct. Meaning there could be something else that renders the salah invalid. There could be something else that renders the salah invalid. On condition of you having wudu, your salah qualifies to be invalid. So when we talk about these conditions, on condition of you fulfilling these conditions, then your transaction qualifies to be valid. These conditions are connected to these pillars. So let's go through them very quickly. Number one, إلا أن تكون تجارة عن تراض منكم. The transaction should not be something forced upon any one of the two parties. It cannot be a situation whereby someone was coerced into entering into the transaction. Enter into the transaction or else. So he was forced to sell what he didn't want to sell. If that condition is not met, is the trade or the transaction valid or invalid? Invalid, because this condition wasn't met. Now this is different, of course, to when a judge coerces someone in debt to liquidate some of their property to look after the benefit of the creditors. This is a different matter. This is an exception. And there's always going to be exceptions to the rule. But exceptions to the rule because of other evidences that govern those exceptions being valid. And no doubt here there's a greater maslahah. If somebody borrows from people and they're not paying them back, and it's time to pay them back. Now there's harm that's being created and it goes to the courts. The court has to effect justice and reduce harm, if not remove it completely. So if it cannot cover all the debt, it will cover the debt based on a price on the dollar, for example. So that's different. We don't say that, no, the judge now has forced me to sell my property, he's forfeited a condition. From the conditions of trade, it's not permissible. No, this is an exception. This is an exception. And thus we see the Sharia has a hierarchy. There's a hierarchy in the Sharia, but not an absolute hierarchy. There's no absolute hierarchy in the Sharia. Every tier has a tier above, and every tier has a tier above until Allah subhanahu wa ta'ala. وَفَوْقَ كُلِّ ذِي عِلْمٍ عَلِيمٍ, as Allah teaches us in Surah Yusuf, that Allah is above all. And ultimately, remember what we said, transactions are based on mercy and justice. So if justice is being forfeited and this condition is being used to justify it, no, the Sharia won't support this. This would fall under the exception, and the Sharia will have other citations to correct this. طيب. That's number one. Number two, second condition, both the buyer and the seller have to be legally competent. So now you can see these two conditions are connected to the buyer and seller. Remember we said from the pillars of the buyer and the seller. We said there's conditions connected to these pillars. The first one, both the buyer and the seller shouldn't be forced. Number two, they should both be legally competent. What do we mean when we say legally competent? Well, Allah subhanahu wa ta'ala says, وَابْتَلُوا الْيَتَامَى حَتَّى إِذَا بَلَغُوا النِّكَاحِ. The orphans, they have a right to their wealth. And their wealth will be under the protection of who? Of the guardian. But the guardian is only protecting their wealth. When they get to the age of puberty, they have a right to their wealth. They're adults. And they're obviously adults, meaning they're adults and sane. They're legally competent shar'an. Yeah? They are baligh aqil, as we always say. They've reached the age of puberty and they have sound mind. Now they have a right to the wealth. But do they have a right to the wealth just yet? No. When it comes to money, Allah adds an additional condition. They have to be not just of sound mind, but of sound financial mind. They should have a sound mind, meaning they know right from wrong, but also in buying and selling, they have transactional maturity. Transactional maturity. Then give them their wealth. Why? Because the reason why the wealth was sitting with the guardian in the first place was to protect the wealth. Now if you give it to them and they don't have transactional maturity and they start buying things that are cheap for a price that's more expensive, is the wealth protected or is the wealth lost? Lost. So here, both the buyer and the seller have to be legally competent. And legal competence in transactionary law means they are baligh, they are mature, they have reached the age of puberty, they are aqil, they have sound mind, they're not considered insane. And number three, they have financial maturity. Allah says in another verse in the Quran, and do not give the weak-minded your property. So this is other evidence. Then the scholars discuss an exception, because you must be thinking right now, but I give my young 6-year-old boy money to buy a packet of crisps from the tuck shop. This is a transaction, not so? When you give your young boy $10, $15 to go to the tuck shop to buy something, isn't that a transaction? He's engaged in a transaction. We just said here, from the conditions of trade is for both the buyer and the seller to be legally competent. Now the condition is missing. Does that affect the transaction? We always do this. Pocket money, go buy what you want. This is a norm, isn't it? Is this okay or not okay? The scholars, they say this is an exception. And the exception is confined. Confined as follows. Number one, that they buy something that is considered invaluable in the norms of our living standards. A packet of crisps, is this considered expensive or not? Is it considered valuable or not? Packet of crisps, a small box of juice, some sweets, chewing gum. So every norm has different thresholds for understanding what's considered a little and what's considered a lot. So if it's considered a minuscule amount, this is an exception to the rule. You send your child to the shop, here's the money, go buy a loaf of bread. Are you with me? Are you with me, guys? Because if you don't talk, I'm going to also pack up and go. I have enough to do. I have Jumu'ah today, I have night lecture today. You have to communicate. Huh? Taking notes. No, there's a lot not taking notes, they're just staring at me. There's some teachers, mashallah, they allow the children to sleep, the students to sleep, with the eyes open. I'm not one of them, ma'alish. So for them to be competent, legally competent, and this is the exception. But what about if they buy something expensive? They're 12 years old, for example, or 11 years old, and they go and buy a car. Permissible or impermissible? Huh? The default from your understanding, from what we've just discussed, would be impermissible, except if the guardian gave express permission. Express permission that is not open to doubt. So in this particular case, the person engaging in the transaction, they actually are proxy on behalf of who? The guardian who gave them permission. The position of the person in the transaction has changed. They're no more just the buyer, they are buying on behalf of who? The guardian, because the guardian has given them permission. Even though they're buying on behalf of themselves, but they needed power of attorney, as we say, from the guardian, because the guardian is responsible over their wealth. If the guardian didn't give them permission and they bought a car, or they bought something expensive, let's say they bought a book worth 100 Australian dollars, 150 Australian dollars, the transaction can be reversed. Are we clear? So what's the second condition? That they're both legally competent. And one added point we said here was they have to be financially mature. واضح? Clear? Okay. Number 3. So let's say they get to the age of puberty. They're 15 years old. Let's say they're 20 years old. They know right from wrong. Nobody considers them insane. You give them a car, they go to the masjid, they go to school, they come back, but they don't have financial maturity. It's known that they don't have financial maturity. Their chances of being cheated very high. What happens here? Can the transaction be reversed? Here a judge can. Yes, because they don't have financial maturity. They need to have financial maturity. وَابْتَلُوا الْيَتَامَ حَتَّى إِذَا بَلَغُوا النِّكَاحَ فَإِنْ آنَسْتُ مِنْهُمْ رُشْدًا فَادْفَعُوا إِلَيْهِمْ أَمْوَالَهُمْ إِذَا بَلَغُوا النِّكَاحَ وَمَا meaning if they, I'm speaking in Arabic, afwan. If they reach the age of puberty and you don't see within them financial maturity, you're not allowed to give their money to them. That's determined. You test them. Allah says, وَابْتَلُوا الْيَتَامَى. Give them an amount, see how what they do with it. Yeah. Yeah, but it's not a transaction. You are responsible. Sahih. Would you give your car to a child who's not mature? He knows how to drive, but he's not mature on the roads. So again, you test your child, isn't it? Which father just says, you passed your license, here's the car, go. Take it to a more spiritual realm, yeah, Munir. You give him the car, he doesn't smash anybody, but he goes to the disco. Would you give him the car? But is he transactionally mature? Does he know how to judge price? Does he know how to judge product? But is it his car? Yeah, he's using your car. Okay? But what's that got to do with our session today? Because that's a different transaction. This is not bay'. When you give your child your car to go to the masjid, you're not engaged in bay'. نحن في كتاب البيع. هذه كتاب أنت تعير السيارة. أليس كذلك? This is باب العيارة. This is different. But what we're saying is money to buy. You send him to buy a car. He has, for example, 20,000, and he has a wife, and he has a marriage coming, and he has responsibilities, and he goes and buys a car for 30,000 with credit on top. هل هذا عاقل في financial transactions أو غير عاقل? You can tell him when he comes home. Will you tell him, "MashaAllah, tabarakallah, ahsant"? Or will you say, "Subhanallah, I thought you were عاقل يعني. How did you make this decision? You have these expenses coming, and you took all your money, and this is what you did. You were supposed to buy a car for 5,000. I didn't think I had to teach you this. Now you realize, subhanallah, this person, we have to train him before we give them full financial control of their wealth. So if a person who doesn't have this ability, they're baligh, they're aqil, and they don't have this ability, they don't have financial maturity. This is the condition. Financial maturity. Hadi finance. Financial maturity. Then you don't give them their wealth, even though it's their haqq. It's their right, but until a period of time. And sometimes we see this today. For example, a person passes away, they leave wealth in inheritance, but the children are young. They put a citation in the will until the age of such and such, or until they get married. For example, the money has to be held in trust. It's their haqq, but until they get married. This is to protect the right of the recipient. So the Sharia is saying, initially, the guardian is looking after the wealth of the child to protect the child's wealth. It doesn't mean the child now became baligh, aqil, you just give them the wealth to waste their wealth. It was being protected all these years. So give it to them when you are confident it will be protected. Now after you've done the test and you've determined بِغَلَبَةِ الظَّنِّ, you have preponderant knowledge. Remember we discussed preponderant knowledge last year when we said الْيَقِينَ لَا يَزُولُ بِالشَّكِّ. You guys forgot, it was too long ago. Lesson was 10 years ago when we did قواعد الفقهية. Preponderant knowledge. And then you give the wealth, and then they spend it in a manner that's not responsible. You're not sinful. You're not sinful. But if it went to a judge, the judge now will have to decide based on the circumstance, whether he was taken advantage of, he wasn't taken advantage of, and so on and so forth. The point is, this is the condition. You need to be baligh aqil. But when it comes to finance, the Sharia adds what else? Financial maturity. And in Brother Munir's example, he's right. In a different realm, when you lend someone something, you see, the Sharia has a general rule. We set up people to succeed, not to fail. This is a qaida muttarida across all the abwab. You set up people to succeed, not to fail. That is why Allah doesn't make taklif upon you, as a matter upon you, until you have complete aql, until you reach the age of puberty. Because the Sharia is setting you up to succeed as well. So it doesn't hold you accountable before the age of puberty. Even when you lend someone something, you are well within your right to means test it. This is called means testing. Means testing. Even in zakah, if you give zakah and you see this person doesn't have financial maturity, they are in need, they have a family, they have bills, but he's buying cigarettes. Do you say, baligh aqil, give him the money? It's connected to this وَابْتَلُوا الْيَتَامَى حَتَّى إِذَا بَلَغُوا النِّكَاحِ. Because here, the haqq of the zakah and the maslahah of the zakah is going to be forfeited. Sometimes you give people sadaqah, they buy alcohol. Do you say, he's poor, give him sadaqah, I'll be rewarded by Allah? No, if you know, and Allah knows all, that you know what this person is doing, and you still gave them the sadaqah, this is not sadaqah. This is al-i'ana ala al-ithmi wal-udwan. This is not sadaqah, this is assisting someone in doing haram. It changes. The ruling changes. So this is from common sense. And this is what the Sharia states, that both the buyer and the seller must be legally competent and have financial maturity. Imagine you give your son a car, then he sells that car. We spoke from the position of the buyer, someone using money to buy. Imagine if they sell the car for cheaper than market price. Because you saw in them, they feel sorry, they have a soft heart still. Huh? Do we know people around us? MashaAllah. So they sell cheap. Say, brother, but why are you selling cheap, ya akhi? You have debt. You have a business. You're trying to start a business. You're already giving discount? How are you going to manage there's a problem here. You need financial advice, isn't it? So this is what we're talking about, that sometimes people can sell their things and put themselves in financial difficulty. If this is raised to the Islamic judge, the Islamic judge can start reversing transactions, especially not in all circumstances, but in some circumstances. Let's say there's people who need to be paid. They lent this person money, and this person didn't use financial maturity in how they started their business, and now the business is in debt. The judge can come in and say, no one is allowed to give this person money anymore, blocked. It's called hajar. And meaning this person is isolated. And also, he's isolated from engaging in any transactions. And also maybe everything that he has needs to be assumed by someone who will act in his best interest and sell it at the right price, and the profit from it is to pay the creditors. Meaning there's options here that the judge will use at his discretion. And ultimately, what we're learning now connects to Bab al-Qadha. Because when financial transactions enter into dispute, it's the judge who has to rule. He's going to be using the fiqh of Kitab al-Buyu' here. So let's say it's established by people that this person, he's not financially mature. He's got a record, subhanallah, of making poor decisions. The judge will use this. Anyway, for now, you need to get the condition. What is the second condition? Competent, legally competent, meaning baligh and aqil. Baligh and aqil. And the Sharia adds financial maturity when it comes to understanding aqil. Baligh aqil. He's of age and he has mental sanity, but here mental sanity also includes financial maturity. In marriage today we say, what do we say? We say marriage maturity also. Someone's laughing. Marriage maturity, yes, it's true. You have, mashallah, your son, he is baligh, he's reached the age of puberty, he is aqil, mashallah, he can, mashallah, at the age of 16, he can go into a law firm, mashallah, tabarakallah, and do some amazing things. Even the lawyers, they are saying this person is amazing. What he's doing at 16, we did at 26. But in marriage, he's not mature. Doesn't know how to manage the responsibilities of being a husband, of managing a home. He knows how to manage a career, but can he manage a marriage? That's the matter. The Sharia talks of marriage maturity when the Sharia talks of kafa'ah. Anyway, before this goes into marriage, let's shift. Okay. So we said they are both legally competent. Now, number three, third condition. Both mediums of exchange have to be owned by the people exchanging it. The money I'm paying, I need to own it. And what you're selling, you need to own it. If I'm using someone else's money, I need their permission. If you're selling someone else's product, you need their permission. And if you are selling someone's product, then you are not the seller, you are an agent on behalf of the seller. And if I'm using someone else's money to buy it for them, I'm not the buyer, I'm an agent on behalf of the seller. You see how fiqh shifts the considerations from it being a transaction between a buyer and a seller, it became now a transaction between the agent of a buyer and the agent of a seller, and the rules change. Some of you are asking me about drop shipping. There's fine lines between halal and haram in drop shipping. Fine lines. It's how both parties understand each other in the transaction. If you don't own the product and the person buying understands you to be the seller, there's a problem. And many people, when they open the drop shipping page, the description they put is the description of one who actually owns the product and is selling the product, not the one who can source the product, not the one who is selling the product on behalf of the seller. From a Sharia perspective, all these matters have consequences, especially when the dispute arises and it goes in front of the judge. The judge will tick these boxes, he will understand these lines of separation, and accordingly he will apply the fiqh. And fiqh is a very precise science. When you're sitting here listening to me, you think, subhanAllah, but why does this matter? Why does this matter? From a fiqhi perspective, it matters because the application of the Sharia is very precise. Sometimes there's a fine line between profit and riba. Fine line. But the Sharia can see those lines, and thus it rules this to be profit and halal, and this to be riba and haram. And even at the time of the Quraysh, when the rules of riba came down, what did they say? إِنَّمَا الْبَيْعُ مِثْلُ الرِّبَى. That's what they said. They said, but hold on, the money we make from the buying and selling is the same like the money we make from riba. Allah said, وَأَحَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَى. There's a fine line. The difference is Allah made buying and selling halal and riba haram. What were the Quraysh referring to? They were referring to deferred sales. When we sell a product on a deferred basis, we always ask for more money. So when we give money on a deferred basis, we get back more money. What's the problem? If I sell my phone, cash, $1,000. And if I sell it deferred, pay me back in 12 months, $1,200. Is it more expensive or less expensive? More expensive. Because it's deferred. Because you're paying me later. I'm assuming risk. So the Quraysh said, when we give our money, and you pay me back in 12 months, you got to pay me more than I gave you. What's the difference? There's a fine line, there's a difference. The difference is Allah made buying and selling halal and riba haram, meaning Allah permitted you to make money through the means of exchanging services and goods, but not through the means of exchanging money. Money is sterile. Money doesn't give birth to money in the Sharia. Money only gives birth to money through the means of through services and goods, the exchange of services and goods. And daman, but that's a different, I don't want to take you down there. Liability, but inshallah we can touch on it later. Are we good? Good. Alhamdulillah. Can you have a question? As long as you don't take me to Sydney. Go ahead. Although Sydney is warmer than Melbourne. Naam. Yeah. Yeah. Did I say something else? Okay. Yeah, 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 you see, in your mind, remember we said be precise. What's the difference between what you said and what he said? Sorry? No. Your one had goods that would be exchanged. That's the point. What makes your transaction halal and you have the ability to dictate the price and he can't do that? What's he? The car. You're selling a product. He's not selling anything. He's selling money. Money, you can't sell money. Subhanallah. This is what I'm saying, brothers. Ayyuhal brotherun. The Fajr brothers. You need to have your coffee before coming to a fiqh of transactions class. I wonder who was the amazing, intelligent person, mashallah, tabarakallah. Allah bless him. And when I saw fiqh of finance after Fajr, I said, inshallah, let's see who is going to manage. You are confused because you're not thinking. You got to think. And a lot of the times we blame the Sharia because you haven't got it right in your mind. The Sharia is precise. There's subtle differences. Figure out those differences. There's a difference. The same thing you disputed with him, you didn't dispute, but you asked to make sure, is what the Quraysh was saying. Why when I sell something deferred for more money, it's okay. But when I give money deferred for more money, it's not okay. Because there's a difference. You see, when the light bulb goes on, subhanallah, you think I'm going to go and learn fiqh now for that. It's amazing. It's addictive. Wallah, it is. When you finally understand these subtle differences and how the Sharia applies it, it really becomes so addictive. And you spend your lifetime studying fiqh and reading. You know, there's a science in fiqh called al-furuq al-fiqhiyya. Al-furuq al-fiqhiyya. Voluminous works have been written on this. Al-furuq, famous one of Imam al-Qarafi, rahimahullah. Al-furuq. All it does, it tells you, it brings together two similar circumstances and tells you the difference between them. Two similar circumstances, the difference between them. From Tahara, from the Babul Miyah, the chapter on water, all the way to the chapter of manners, morals and etiquettes. That the fuqaha actually thought about this. This circumstance and this circumstance, these are similar, let's put it there. This circumstance and these are similar, let's put it there. And then the subtle difference between them. When you read this, it builds up your fiqh ability. SubhanAllah. And we spent a long time studying this. I was fortunate to be taught this by the Imam of the Haram, Sheikh Salih bin Humayd. Hafidahullah. Fascinating teacher. Fascinating. And fascinating topic. SubhanAllah. Mind-blowing experience. So, you know, when your eyes lit up, mashallah, you guys can't see. I saw the brother, wallahi, I lived you many a time. MashaAllah. But this is it. There's these differences. There's these differences between them. The difference between your scenario and his was you put a car. Yeah. No. What's the difference between the car scenario and the phone scenario? Yeah? Who said? So you're still not understanding it. No. Yeah. You're not changing the price. Why are you saying you're changing the price? The deal hasn't been done. The seller is telling you, pay me cash 1,000 or buy it over 12 months for 1,200. What do you want to do? Again, that light bulb went up. I seen it in his eyes. I told him the light bulb went up and he goes, no, I wasn't comparing that. Now the light bulb went up again. The deal didn't go through. When the deal is done, yes, you can't change the price. When the deal is done, that's the price. If you change the price, let's say he comes to you 3 months later and says, I can't pay you my installment for this month. And then you say to him, if you can't, then you owe me 1,210. That's riba. Because now, someone owes you money. When he took the phone, he owed you 1,200. So it's equivalent to you having lent him 1,200. His position is similar to someone who borrowed money. Now it becomes a money for money transaction because you are increasing $10 on money or via goods and services. Yeah, let's take you through the furuq now. Go through the journey. Now you see how the transaction shifts. Once the deal is done, I owe you money, right? If you increase, are you increasing on money or are you increasing via goods and services? That's riba. Because money is giving birth to money. Do you see the difference? That's why late payment fees is riba, by the way. Any transaction with late payment clauses, it's a riba. It's got a riba clause in the contract. But now it's become everywhere, late payment clauses, school fees, phone bill, electricity bill, it's everywhere. So this is from what the scholars call umum al-balwa. Umum al-balwa meaning it's a difficulty that has encompassed everybody. And if we maintain the original rules of the Sharia, that you're not allowed to enter into these contracts that have an interest clause, it will create a difficulty that the Sharia doesn't intend. The Sharia is built upon the concept of raf'ul haraj, the alleviation of difficulty. But by implementing this rule, a difficulty is going to ensue that is beyond the threshold of difficulty that the Sharia allows. So the Sharia will relax the ruling and say you can enter into these contracts on condition you don't activate the clause. On condition you don't activate the clause, meaning you pay within the period. You don't activate the late payment period. Does that make sense? Naam. And that is why some scholars say you should have buffer amounts to manage these contracts that have late payment clauses in it, in case your job circumstances change, your financial circumstances change, you have money that gives you time to avoid falling into what they call breach of contract, and then you can sort out your financial position in that period. This is from financial maturity, by the way, brothers and sisters in Islam, from an Islamic perspective. Now, guys, if we carry on, we will not finish. If you're taking me down your individual, you make me your personal financial advisor, we will not finish. You have to understand it macro level. I can't answer every, because I know, and I teach this a lot. I teach this a lot. And I know what happens. As soon as I'm teaching, nobody's listening to what I'm saying. They're thinking of their own personal transaction. 10 years ago, I did this. 5 years ago, I did this. So you miss what I'm saying, and then you pull me into your mind. But then I have 100 other students on the side. We'll never finish. Yeah? So let's focus. We won't get through conditions of bay. I wanted to take you into al-manhiyat, at least the beginning today. Okay. Understand the concept. What is the third condition? Huh? Owned. You have to own what you sell. Do not sell what you don't own. This is a condition. Now what happens if I, for example, sell your car without your permission? This is stealing. No, I give you the money. I come to you one day, you wake up for Fajr, you say, where's my car? La hawla wa la quwwata illa billah. Let me call the police. And I say, no, brother, subhanallah. I sold your car last night. Here's the money. What's the ruling? I didn't own the car. The fuqaha have two views here. The judge will either reverse the transaction, and the other view states that the judge will ask, or it depends, meaning al-bay' mawquf ala idhn al-malik. The transaction is dependent on the permission of the owner. When I come to you with the money, you can decide whether you're happy or you're not happy. If you're happy, you say, subhanallah, you sold it for this amount. Barakallahu feek. Then the deal is done. But if I come to you with the money and you say, La ilaha illallah, this car, I don't care how much you sold it for. My father gave me this car. I'm not happy. Then the transaction is reversed. And this is the view that I consider closer to the evidence. Because whenever a transaction happens, there's a cost. And reversing transactions creates a greater cost. Not so? So if there's a chance for us to correct the transaction, then we should. And this is the madhab of some of the fuqaha, especially the Hanafi madhab. The Hanafi madhab has a principle in Islamic transactions. And it states, تَصْحِيحْ الْبُيُوعِ بِقَدَرِ الْإِمْكَانِ. Try and correct the transaction to the best of your ability without reversing it. Because reversing it has a cost. As you know, inflation changes the value of money. When you bought the car, you could buy X amount of loaves of bread with that money. Now when you got your money back, you could buy less amount because of inflation. Maybe the market changed. And when the market changed, what happened? The value changed. So there's consequences. So the judge will take this into consideration. A lot of the times now, in terms of contemporary qada, they try and correct the transaction بقدر الإمكان. Anyway, I'm taking you deep into the application. طيب. Now, what's the next condition? Number 4. The ability to acquire the purchased or sold goods. The ability to. When you're buying it, it might not be available, but you should be able to get it. Which means what? This condition puts an end to gharar. نهى النبي صلى الله عليه وسلم عن بيع الغرار. The Prophet صلى الله عليه وسلم forbade ambiguous transactions. What does this mean? Can I come to you and say, brother, I have a camel, this is its age, this is its size, this is its make, meaning its lineage, yeah? This is its price, but it's lost somewhere in the desert. Let's do the deal. Allowed or not allowed? This is gharar. This is gharar. Let's say I come to you and say, I'm selling you a barramundi, fish. But it's still swimming in the sea. It's still swimming somewhere there, and you give the details, this weight, this size, this color, but it's still swimming in the sea. Allowed or not allowed? This is a gamble. The Sharia forbade gambling. And when the Sharia forbade gambling, the Sharia is complex. The Sharia forbade gambling. Gambling is from lahu, when you're playing. The Sharia came to transactions and closed the door to transactions resembling a gamble. See, the Sharia is very complex. It knows if we close the door here, they might come to the halal one and try and gamble through halal. They say, no, buying and selling is different to playing. I'm not playing. Gambling is in playing. This is buying and selling. So the rule should be different. The Sharia closed the door here. Naha an bay'il gharar. So this is the 4th condition. طيب. The 5th condition. The knowledge of the mediums of exchange by both parties. I need to know what I'm buying, and you need to know what currency you're getting. Imagine we do a deal on a car. What's the price for a good car here in Australia? $20,000? Huh? 30,000. Wow. What car is that? Normal, $30,000. Wow. Subhanallah. Some people are saying, la, ghir sahih. You sell cars? He sells cars. So he's more mature to tell us than the rest of you. $30,000. We do the deal. And then I come to you with Zimbabwe dollars. I say, we said dollars, brother. Zimbabwe dollars. What happens? Problem, isn't it? We need to be clear. 30,000 Australian dollars. Let's say we're doing pounds. And then I come to you with Egyptian pounds. We do the deal, 15,000 pounds, for example. And then I come the next day, mashallah, with my briefcase of Egyptian pounds. You say, la hawla wa la quwwata illa billah. No, I don't want to do the deal. I say, I'm going to take you to court. We made a deal. There was offer and acceptance. You offered to sell me the car for the amount? I said yes. When we go to court, what will the judge look at? He'll say there's a flaw in the trade. The information wasn't clear. The information has to be clear. Now, how is the information clear? Either by you seeing what you're buying from the perspective of the buyer buying something, or by a description being offered, and the description has to meet the following condition. The description has to detail everything that will affect the price. So if color is going to affect the price, the color must be mentioned. If mileage is going to affect the price in the case of a car, the mileage must be mentioned. If the type of tires on the car will affect the price, the tread, it should be mentioned. Do you guys have MOT here? What do you call it here? Roadworthy. Yeah, in the UK it's called MOT. If roadworthiness, the period of roadworthiness, because it's 12 months, isn't it? Is it at the end of the period or at the beginning of the period it's going to affect the price? It should be mentioned. If any detail that should be mentioned in terms of the price being affected is omitted, yeah, then there's a defect in the advert. And the buyer must clarify before engaging in the deal. And today, with cryptocurrency, I'm opening up a can of worms. But in cryptocurrency, many people say, Sheikh, allowed, not allowed, allowed, not allowed. I tell the brother, tell me about this crypto, this coin. Yallah, tell me. This, okay, well, what about this? You can see he's guessing. He doesn't know what he's buying. He doesn't know. He doesn't know. In fact, I'm convinced that the majority of crypto purchases, they have not read the white paper. They have not read the white paper of the crypto. They don't know what they're buying. They're just going into it because of the fear of missing out. That's what it is. That everyone's making money from it, I'm in it, but you don't know what you're buying. What is the utility of the crypto? I don't know. Who invented this crypto? I don't know. When was it born? I don't know. What does it seek to achieve? I don't know. So why are you buying it? How is the price point determined? I don't know. Is the transaction halal or haram? Forget about is the coin halal or haram. Sometimes the matter you're buying can be halal, like in the case of the car. But the condition for it has not been met. It's an invalid transaction. You see, fiqh is precise. It looks at these things. When you stand in front of a judge, he's going to determine these things. And some people say, why is the judge taking so long? He's asking things of common sense. Common sense is not so common. Common sense is not so common. Common sense is not so common. Tayyib. So the knowledge has to be known. That's number 6 or 5 or 4? 5. Tayyib. Number 6. No, we'll leave it at that, inshallah, because the others are connected to what we just discussed. Knowledge of the price. Knowledge of the product being bought, knowledge of the price, I said it to you. The fuqaha sometimes add it as one condition or as split conditions. Knowledge of what you're buying and knowledge of what you're paying. Okay? So these are the conditions. Tayyib. Now I want to explain to you something very important before you go today. And may Allah help us tomorrow, because riba is a long one. Riba is a long one. I don't think we will get to do it. And we have to talk about gharar and oppression. We'll have to maybe come back next year and just focus on al-manhiyat. What I'm going to share with you is very important. I want you to pay attention. Because again, this is from the furuq, from the differences. And these differences have an impact. The Sharia differentiates between acquisition of the purchased product versus the purchased product. Acquisition of it versus the purchase of it. And the threshold for understanding the purchase of a product versus the acquisition of a product is liability. Is liability. What is liability? Liability in Arabic we call it daman. Daman. When I buy something, I own it. Correct? I bought from the brother a car. And by the way, let me take you back to the beginning. In Islam, predominantly, what did we say? Or what did we say is a pillar from the pillars of trade? Ijab wal qabul. Offer and acceptance. Commission of, what do we call it? Commission of contract. Commission of contract entails the transaction being completed versus not completed. If I come to you and say, brother, how much is the car? $30,000. Give me the description. He gives me the description. I say it's Australian dollars. It's Australian dollars. Done. I'm buying the car. The deal is done. The deal is done. I can sit in the car and drive off and I owe him $30,000. Unless he says no, shurut fil bay', this is different. Conditions between us is you have to pay me before you drive off. It's a different matter. But the deal is done. I owe him the money and he owes me the car. Just like a marriage contract. If a father sits with two witnesses and a boy and says to him, I marry you, my daughter, for a mahar of, what's a fair mahar in Australia? MashaAllah, tabarakallah. Everything is thousands here. Allahu Akbar. Imagine the brother who went and bought the car on credit ba'd, and he needs to get married. How is he going to manage his nikah? So 10,000. The father says to the boy, I marry you, my daughter, in front of these two witnesses for 10,000 Australian dollars in mahar. And the boy says, yes, it's done. It's done. She is his wife. She is his responsibility, not the responsibility of the father. There's consequences in what we say. Consequences. In Islam, you're a man of your word. But obviously today it's moved on. We consider the negotiation the precursor to the written contract. Our norms have changed. Today, when is the contract considered to be done? When we sign on it. But let's be honest, today sometimes we go online and we buy. Not sometimes, all the time, we're buying things online. Who's speaking to each other? Commission of contract, how is this exchanged? By clicking on the purchase button after seeing everything. And consumer rights protects you. If you get the product and it's different to the one described, you can reverse the transaction, isn't it? When you go to a vending machine, where's ijab and qabul? You need to get a healthy snack from the vending machine. Not an unhealthy snack, a healthy snack. How does ijab and qabul happen? By you putting your money in, by you pushing the buttons, by you pushing accept. And then what happens? There's qabul. What's qabul? When it accepts the money and you see the machine moving inside, picking up your product, and it comes. If it doesn't come, what happens? People start kicking the machine. Because there's a transaction that took place. You stole from me. Isn't it? So ijab and qabul happens in different ways. Now, when ijab and qabul happens, I've purchased the product. But when am I responsible for the product? When does liability transfer? When does liability transfer? This is important, brothers and sisters in Islam. That's why I need you to focus. Because like drop shipping, this is another thing. When does liability transfer? Liability transfers when I have acquired the product. If I buy his car and I don't receive the vehicle, who is responsible for the car? He is responsible. So who carries the liability? He carries the liability. If the car is stolen overnight, la qaddar Allah, do I get my money back or do I have to pay him the money? Who's carrying the liability? He has to give me another car for the money that he's taken, isn't it? So he carries the loss. Because he carries the loss, I'm not allowed to sell the car. Even though it's my car, I'm not allowed to sell the car for a profit. I'm not allowed to sell the car for a profit. Why? Who holds the liability? The seller. But whose car is it? The buyer. But because he still holds the liability, the Prophet sallallahu alaihi wasallam naha anil bay'i ma lam yudman. The Prophet sallallahu alaihi wasallam forbade selling something that you do not guarantee. You do not hold its liability. So even though it's my car, let's say my brother came to me and said, Subhanallah, I'll buy the car for you. Can I sell it to him for 35,000 and make 5,000 profit whilst my brother here holds the liability? Yes or no? No. Somebody might say, it's not making sense, ya akhi, but it's your car. This is what many of us miss. And this is perhaps the most important lesson you will take this year from this series. Because this is the differentiator between riba and non-riba. If you guarantee yourself a profit, it's riba. Take this as a qaida to start with. When I buy the car from him for 30, And I don't stand any chance to lose, because even if the car gets stolen, he has to give me a car. I have nothing to lose, and I sell it for a profit. Is that a guaranteed return or not? Guaranteed return or not? Why is it not a guaranteed return? So that's a guaranteed return for me. I'm guaranteeing my returns, correct? And I'm making a profit on top of that return, correct? The Sharia says this is the same as a person who lends money and guarantees the return, because when you loan, someone has to pay you back. If they don't pay you back, you can go for the property. If they die, you can go for the inheritance, correct? So that's a guaranteed return. You're not allowed to take more money on that money. So the Sharia closed it in riba and closed it through riba, through transactions. The Sharia says, when can I make 5,000 on the car? When I assume the liability of the vehicle. When I sleep at night with the stress, what if the car gets stolen tomorrow? That stress qualifies you to make money on that car. Remember we said, I'm going to take you back to the first, when we spoke about the Islamic economy. We said the Sharia, part of the economy, is built on for-profit transaction based on equity and, why did I add this here, equity and justice? Because it's not equitable and it's not just when I'm making money without carrying responsibility. It's as if the Sharia is saying, when you have this phone, you have to charge it, you have to look after it, you have to save it from getting scratched, you got to make sure you don't leave it somewhere that someone steals. Every day you have this, you are busy with it. I left my phone, it might get stolen, I need to rush back, get my phone. Because you lived with that stress every day, with that responsibility, let's not call it stress. You lived with that responsibility every day, you qualify to sell it for a profit. واضح? People are loving it, I can see the smiles, I love to see the smiles. Because this is the most important thing you'll take away. And many of the contracts that we have problems with today, it's due to this, and the people don't understand why. And the financial crisis that happened is connected to this problem. A barrel of oil would be sold 100 times, bought, sold, bought, sold, bought, sold, bought, sold. How many people are transacting whilst the oil is still on the ship and the ship is still on the sea? Profit is being made and no actual products being exchanged. And people are making money off nothing. Guaranteed returns, because he owes me and he owes me, and now the price has gone up, the next buy it goes up, the next buy it goes up. The oil is still on the sea, but the price of oil is being dictated. And that's why derivatives are haram. Derivatives are it's all about this, it's this gambling. Someone thinks the price is going to go down in 6 months, he finds someone who thinks the price is going to go up in 6 months, and they go into the deal. When 6 months comes up, nobody needs a barrel of oil. They say, I said this would happen, you said that would happen, who won, me or you? You won. What's the difference in price between my price and your price? $5, here's $5. Let's try it again. After another 6 months, he wins. He goes, well, here's $6. It's called contract for difference. All you're doing is exchanging the differences in prices that you agreed to without anything being exchanged. No liability being carried. You're making money. This is gharar and this is riba. Now, when does liability come to me? When he delivers to me the car, number one, or when he says, Sheikh, the car is ready for you to pick up. And I say, you know what? I'm traveling, I'll pick it up on Monday. Now liability is with me because he told me to pick up the car. I told him, please keep the car for me as a favor. How does the Sharia translate what I said to him? You might say, I told him I'll pick the car on Friday. The Sharia says, no, you didn't tell him you'll pick the car, on Monday. The Sharia will say, you told him, Jazakallah khair, my brother, can you look after the car for me till Monday? And this is known as Bab, or this is known as Al-Wadi'ah. There's a chapter in fiqh, the chapter of Wadi'ah. It has different rules. You might say, no, this is a transaction. The judge will say, no. The transaction was previous. This is a different transaction known as Wadi'ah. The rules are different. So if the car gets stolen on Saturday, la qaddar Allah, does he owe you a car? Who carries the burden of the loss? So can I sell the car to my brother for a profit? وصلى الله وسلم وبارك على نبينا محمد وعلى آله وصحبه أجمعين. الحمد لله. You are Sharia compliant. Stamped. So when you think of your drop shipping, etc., you got to think about it like this. In drop shipping, what's the haram one? The haram one is when you're selling something you don't own. You're making a profit on something you don't guarantee. That's haram drop shipping. No scholar will tell you that's halal drop shipping. But there are halal versions. Remember I said the Sharia doesn't make something haram except that it comes with alternatives. Remember, in drop shipping, from what we've learned, if you sell something without carrying its liability, its daman, the money made from it is haram. But there's alternatives. I shared with you an alternative yesterday, bay'u salam. Bay'u salam. You tell someone, pay the money now and I will deliver what you're asking for in X amount of time. And it's clear that you will deliver. You're not holding the product. You don't own the product. Or you become an agent. I can source for you this. I have an MOU with the company. The company holds for me X amount of stock. Even if it's not available in the market, I have it frozen as part of my MOU with the company. So you're selling on behalf of the company based on an MOU. This is permissible because the company is going to drop ship it straight to the client and you are managing the interim. Here, the money you make, the Sharia has a different understanding of it. Because if you are making money as an agent, the Sharia calls it commission. If you are making money through bay'u salam, then this is making money through a transaction, this is profit. And the rules of profit are different to the rules of commissions from a fiqh perspective. So you see, the faqih has to think of all these things. And that is why, my brothers and sisters in Islam, when you ask these questions, you need to be daqiq in your question. People come to me, Sheikh, this very quick one. This is a common one. Quick question. It's not a quick question, ya akhi. This question has kitab al-buyu' min wara al-su'al. It has the whole chapter behind your question. It's not going to be a quick question. And people get frustrated today, and the mashayikh, and one of the solutions are that people are starting Islamic finance advisories. It's professionally run, so there's governance, so you can submit your contract, and there's non-disclosure, but it has a cost, so you have to pay. They say, no, why should we pay? But the lawyer, you'll pay how much an hour for your contract, and to read through your contract, how much? Your own mind, you'll say, no, this I can justify. Justified cost. But for your akhirah, no, I can't justify the cost. The sheikh must do for free. That's why I be clear in the courses. Brothers, I'm not your financial advisor. Financial advice needs time. And then how do I give times 100?